Hey friends, welcome to this episode of the Legal Paige podcast. So I wanted to go over something that has been kind of on the forefront of my mind and everybody else's mind in the small business world. And that is if your clients just are not willing to reschedule, they still are just steadfast in wanting to cancel, and they want a refund of some sort. So unfortunately, despite all client communication efforts to really try to work with your clients to get them to reschedule and postpone their wedding or their event date, sometimes they're just going to want to cancel services, and they either want a full refund or at least a partial refund. And since it's really unclear when life will finally get back to normal after this pandemic, clients really may want some financial certainty that comes with a cancellation and a refund. And I totally understand that, especially since lots of people don't know when or if they can actually reschedule. And many of them are working with various different vendors, and some vendors will be able to work with them and some won't. And so sometimes it's just overwhelming and they just want to completely cancel and go back to the drawing board when they feel like it. But it is important for you as a service provider to know how to navigate these waters and still provide support and excellent service to your clients. While it may be tricky to do so, I want to walk you through how to do this with cancellation and refunding clients the right way, the best way, the most service-based way, and of course, the legal way. So let's get into this episode. You're listening to the Legal Paige podcast, where we chat about life and business with a legal twist. I'm Paige, attorney and photographer helping online businesses and creatives tackle their business dreams without breaking out in hives. No more legal mumbo jumbo. This podcast features simple, bite-sized advice that'll have you legally legit in no time. Are you ready? Let's get started. As a reminder, before we get into this episode, I am legally obligated to give my disclaimer. So I am an attorney, but I am not your attorney. All legal information I talk about on this episode is intended for the masses and a large variety of different businesses. I am only your attorney when you hire me and we sign an engagement letter for me to work specifically on your legal issues. Please feel free to seek out another attorney in your hometown if you need specific legal advice or contact me for more information. Alrighty, here's the episode, friends. Okay, so let's just go from the beginning, right? I have talked about many different times why communication with your clients is so important, and it's important for documentation purposes and evidential proof purposes on the legal side of things. But it's also just a really good thing to do as, of course, a customer service-wise and as a service provider. So the first step you should take when you hear or get an email from your client that says that they want to just flat out cancel your services is talk to them. Oh my gosh, what an enlightening idea. Just talk to them. So tell them that you have a plan. You have a plan for all of these COVID-19 situations and rescheduling events, and you are there. You have been well informed. You are keeping up to date with county regulations and state regulations, and you want to articulate what your plan is as a service provider. Of course, nobody saw this coming. And so no one had a COVID-19 clause in their contract related to what their policy was. And we're not going to get into force majeure language. I've talked about that in previous episodes. But you can have a policy in place for COVID because it's new, it's novel, and your business and the reaction to COVID-19 is going to be different depending on your business practices, your morals, your business ethics. But ultimately, you want to try and move your clients towards rescheduling or postponing their events. And I know HoneyBook in particular has great email swipe copy, you guys. If you just go to HoneyBook Rising Tide blog, if you Google that, and then it'll take you to the blog that's what to say to your clients when ... And then they have beautiful, I think they have 10 to 20 different email swipe copy you can use. So you want to take the initiative and send your clients an email communication. An email is important because it's written communications that can be documented. for legal things that could, or sticky situations that could happen down the line. And you want to detail as a business owner how you are handling these times and how that may impact your ability to provide them with the service that they paid you for. You want to inform your clients of the value that rescheduling or postponement provides, as opposed to the hassles that come with a full-blown cancellation. So of course, you're like trying to weigh those options for them, and they might not have an full understanding of how this is impacting all of their vendors and why rescheduling or postponement is better for them because they've already started working with you. They already have a relationship with you. And why it is so good to go with that option versus full-blown cancellation. The goal here is to be willing to perform your services that the clients have paid for sometime in the future. Force majeure, you guys, means you are postponing performance of your services. Force majeure only relates to performance of services, and you are required under force majeure to try and perform your services at some point in the future. Force majeure and an act of God like this, like COVID-19 impacting everybody and anybody, does not mean the contract is null and void. It just means that the contract is going to be performed at a different point in time, as long as your clients agree to that. So you want to work towards ultimately, like I've said many, many times before, a mutual agreement with your clients regarding how they can utilize the services that they've already paid for. They've probably paid for at least a retainment of services, that first, chunk of change that they send to you for a hopefully non-refundable retainer. It should be stated as such in your contract. But they might have also paid for other amounts. If they had payment plans, they've probably paid for more than that. If they have a remainder due on their account 30 days before the event, they could have already paid for that too. Sometimes they pay for it in advance, and maybe you're less than 30 days out and they've already paid for it because the invoice was sent. But you have to try to be able to transfer those services and all fees paid to another date. It's absolutely crucial. Again, I'm just going to highlight this here, that you evidence all of this through email communication, that you are trying your absolute hardest to perform your services at a later date. That's going to be really, really important if you do get into like a sticky legal situation down the road, which honestly, I'm saying like 0.5% maybe of people are going to get into that boat. But the majority of you are going to have clients that understand your position. They have signed on to the contract that you have. They know that they have some obligations that they also have to try to perform or host their event at some time in the future as well, just like you are obligated to try and perform your services that you are obligated to do under the contract. Okay, so now let's think about, rescheduling didn't work. Say you're like 5 to 10 email back and forth in, or you send that initial email and then you jump on the phone with them and you've talked to them and they just aren't budging. Know that this happens. It is a realistic thing that could occur. Your clients may want to cancel and they want the retainer refunded, literally everything. They want everything. And of course, we all understand that right now because people are under extreme financial stress. People want funds returned. They don't know, maybe, their head is just exploding with emotions and fear, and they don't even know if they want to reschedule because when is COVID going to end? So, sometimes clients are just going to choose to cancel and they want a refund. If they choose to cancel, they can cancel, right? You can't force anybody to reschedule or postpone. You can try to persuade them and explain to them why that's your policy and how that works under your contract and how it works with force majeure if you have that clause under your contract. But when this cancellation situation happens, it's crucial to know whether or not you are legally required to provide your clients with a refund of any sort. And it is going to depend entirely on your specific situation and your specific contract language. Because I can tell you, I have looked at 500, 1,000, I don't know, probably more than that, contracts for over the past month. And every contract is different. Some service providers have modified it themselves, have added in language. They didn't realize the repercussions of adding in that type of language. Some people have just Googled things, piecemealed their contracts together. Some people have found contracts from industry professionals. And so they may have like competing language in their contracts. But again, you want to look towards your force majeure clause, your cancellation clause, and your rescheduling clause. You're going to want to look at those in your existing contract, as well as other factors that you need to consider, like how far are you from the event date? Okay, because lots of us have shelter in place or stay at home orders only until the end of April, the middle of May. Like June weddings necessarily, or June events haven't been impacted yet. We will know that at some point in the future, but not now. So again, it's not really a force majeure situation until the government tells us it is at that point in time. So how far out are you from the event date? If they would just want to cancel, like that's under your cancellation clause on the clients doing the cancellation under their own volition, not due to COVID. So you really just need to stay very, very well informed and up to date on, of course, local county laws, and then of course, statewide laws. How much of the contract also has been fulfilled up to this point? Have you rendered any services? Have you done a bridal session? Have you done an engagement session? Are you a wedding planner? Have you planned, 90% of your services up to this point? Have you paid out contractors already, second shooters, associates? Document all of that as well so that you can show the client how these services have been provided and what those services equate to monetary-wise. So if you're having clients pushing for a full refund of the retainer or full fees paid without taking any responsibility on their part to try and cure performance, because it's a dual-sided force majeure clause, right? Well, hopefully your contract says that. Again, you have to look at your contract language, because I have seen, unfortunately, some yucky force majeure clauses that are all one-sided and say, like, if you can't perform, then you're going to give a full refund. Like, well, that's what your clause says. So you're probably going to have to do what you signed off on. And this was the contract you sent to them. So you could get in a not so fun situation, and it's kind of like you bit yourself in the butt there a little bit, right? Like that's the contract that you have. But if you have a dual-sided force majeure clause that says, in the event of either party not being able to perform their obligations under the contract due to XYZ are the force majeure events that are specifically qualified, then it doesn't constitute a breach of contract, but you have to try and cure performance. So that means, like I've said previously, you have to try to perform your services. You need to open up all of these rescheduling dates, tell them the dates that you're available, put that out into the world that here, I will perform. Here are the dates I'm available. Choose one. And then they have to try and cure performance too. They have to try to host the event on one of those dates that you're available. And I get it. They're working with multiple vendors, but at the end of the day, like this is going to hurt all different types of people. And I know some vendor teams, it's like miraculous that 10 to 15 vendor teams for a wedding 10 to 15 vendors, that make up part of the team can be moved to one new wedding date. Like, what? That's crazy town. But it can happen, and I have heard that it's happened. So if your clients decide to choose a date that you're not available and you've laid out like 20 to 30 different dates in, at the end of 2020 and into 2021 that you would be willing to reschedule your services, that's really important to email and communicate with them back and forth regarding how you are available. Legally speaking, they also have to show that they are trying to reschedule and uphold what they signed on to under the contract, since both parties are impacted by Corona. That's kind of the meat of what I'm trying to tell you here. You guys are really stuck negotiating with these clients if they're not budging and they're like, well, we didn't see this coming. This isn't our fault. Like, cancel, give us a full refund. And you're like, well, I didn't see this coming. You signed on to the contract. I'm trying to cure performance and you're not letting me. So that is kind of where the two sides here clash, and my hands are like hitting each other. If you were here, coffee chatting with me, I'm like, this is where the meat of the mutual agreement is going to come down to. So even if your contract says that your retainer is non-refundable, you need to ask yourself, is it worth your time, energy, and money spent on legal fees to argue with your clients over whether that $1,500 retainer is actually non-refundable? Probably not, you guys. It is not going to be worth thousands of dollars in legal fees. It's like bleeding money when you get into a lawsuit. You're going to be way over the $1,500 of your retainer that you guys are arguing over to get into an actual claim or action that would get you into court. Therefore, it's just really better to come to a mutual agreement. And I have been just preaching this from the rooftops. Even if you get a lawyer involved, you have your attorney and then you have the opposing attorney on the other side. And little tidbit of information here, the attorneys are just going to try and settle between them. So that's what they have to do. They're like legally obligated to try to avoid a really expensive lawsuit for their clients by negotiating with the opposing attorney. This is what we all do as attorneys when we get a case to start. We're like, okay, well, can we just try to settle this to avoid any heartache and time and extra money for our clients? And why would you want to pay attorneys right now, $250 to $500 an hour to mediate and try to settle on when you could do it yourself for a $1,500 retainer? Do you see what I mean? You have to weigh all of these things together. So best case scenario would be refund a portion of the retainer or the full fee. If they paid more than the retainer at this point, refund only a portion of that to please your clients. It's not going to be a win-win for both, right? You're going to lose a little bit because you have to refund, and your clients are going to lose a bit because they wanted a full refund and they're not getting the full refund. So a little lose-lose, but it would get them off your back, so to speak. And of course, you want to document this resolution if you two can agree to such resolution with signatures and some type of cancellation contract is what I would suggest, a cancellation termination contract. They're the same thing. And then you're just going to explain in, the refund portion or clause in that cancellation contract. And you guys know we have one in our rescheduling and cancellation document bundle that we sell on the Legal Paige shop. Many of you have bought it. So you would want to use that cancellation contract, and you're going to explain like, okay, your clients have paid X. You're going to refund X. You're canceling, terminating services. Boom, you're done. You two aren't under a contract at any time now or any time in the future. No rescheduling happening. Now, worst case scenario would be, and you guys, I just make this number up because I'm like, I want to see multiple emails back and forth. People are like, why are you saying 10 plus emails, Paige, and phone calls later with clients? Like, why is that a magic number? Because I've talked about that a lot. I'm not saying it's like the magic number. I just want to see enough, right? I want to see you and the client going back and forth, documenting that back and forth, because if you just jump on 10 phone calls with them and that's really hard to document. It's really hard to pull phone conversations. That's like criminal law stuff. It's really hard to do that. So I would, if you do get on a phone call, send an email, just, following up, explaining, outlining what you went over on the contract or on the call with them. And if the clients are still holding their ground, your 10 plus emails back and forth later, and they're like threatening a lawsuit. Unfortunately, this is what I've seen in group forums where, oh gosh, you guys, I have seen some emails from clients where they like kind of quote the emails and they take out all the names, and clients are getting a little nasty. I'm like, oh goodness, this is not good. If they're like, I'm threatening a lawsuit, some of them have, oh my gosh, this was the best, held themselves out to be in a lawyer, like in the legal world. They're not. It was so interesting. This person went and like researched them, couldn't find them anywhere. Lawyers, you can easily just search their first and last name and make sure they're barred in your state. This person was not. So maybe they like went to law school and didn't finish. I don't know, but they're not an attorney and they held themselves out to be. First of all, that's the unauthorized practice of the law. So they're already violating all kinds of ethical rules by doing that. But people are going to like do really crazy things, and many of them involve threatening a lawsuit to try to get you to budge. If they're like holding their ground, threatening a lawsuit, doing this, doing that, saying that they're going to, spew your name online badly, they're going to give you horrible reviews, that's where you probably, I'm sorry, you guys, you probably just need to give a full refund. that would be better than holding on to all fees paid in the retainer and just waiting for them to come after you legally down the road. Like, why would you do that? No attorney would suggest that you do that. Again, these situations really depend on weighing your options and deciding what is the best course of action for you and your client on that very fact and circumstance situation for you both in the long run. Can you come to an agreement that will just resolve it and get it, finalized so you can stop thinking about it? It's not worth your time and stress level and, of course, resources to fight them down the road. If it's like a $20,000 retainer, that's a different conversation that we'd be having. But I'm talking with, to most of you out there who have, $1,000 to a $3,000 retainer. You really, really have to think about, at the end of the day, when you're in this refund land that I call it, it's definitely never going to be that win-win for both parties. A little loss on your part, like refunding a little and a little loss on theirs, not getting the full refund like they wanted, is much better than a full-blown lawsuit. And I promise you, it will let you refund something and then just get yourself like jazzed in the power and be like, I'm going to go find a better client. I'm going to book another another client right now for a wedding at the end of 2020 or 2021, and use that to fuel your hustle moving forward. Okay. Don't let that get you down. Let that fuel updating your contracts so that next time this doesn't happen. Let that fuel you going out and marketing and being a better business owner. And you're avoiding all of that bad word of mouth that could come with a really disgruntled client. So now people have also asked me, what if your client is canceling and wants all the money refunded, not just a portion? Okay. Because I said, you're probably in a lose-lose where you refund a little, but you don't refund everything. That's what I suggest. That's like first step of the negotiation on a refund. But if they're like, absolutely not, I don't want a portion, and they just aren't having it, they want the full-blown refund. This is going to, again, look at your existing contract language. It's also going to depend on the laws and regulations in your state. The big thing to know is that there is no singular law that says you absolutely have to refund your retainer deposit fees paid. Many people have been saying that as misinformation in Facebook groups. I'm like, you're not an attorney. I don't know where you're saying this, and show me the law that you're talking about. I know there was some lawsuit filed in California against a venue owner by a plaintiff's attorney that I think it was a scare tactic to try to get the venue owner to, agree to a full refund. But they were saying under California law, an act of God makes a contract null and void. And I'm like, that would be an interesting lawsuit because, if the venue owner did get an attorney, I'm just like, you can file a lawsuit, but you can't serve clients right. Like, can't serve the papers on someone. It's so hard to get into court right now. It's not even funny. When people are threatening lawsuits, I'm like, good luck filing a lawsuit right now because the courts are like shut down. Everything's electronic. And attorneys are they're going to advise you a full refund is probably better. So here's what you need to consider. If your cancellation and rescheduling clause states that your retainer is non-refundable, then you may be able to keep the retainer payment. If you perform those services already, like I talked about, and you have proof of those services, email documentation, evidence of services performed, maybe cost of goods sold if you're like a florist, or you like supply things for events, then it's further proof that you should be able to keep at least some of the retainer for services that you've already performed. And if you have proof that you've performed more services that were beyond the client's retainer payment, you may be entitled to some additional compensation. That's for all you like wedding planners out there who they haven't, they paid their retainer. You're about 90% of your services have been performed up to this point. You just have to like host the event. But they still haven't paid their final invoice. So this is where you want to, like I said, take a good hard look at the situation, see if you can come to a mutual resolution with your clients. And if you use the word deposit for your reservation fee in your contract, it's very likely a court would say you have to refund that amount. Since you didn't perform your services, it was just a deposit for your services. Generally speaking, courts do not like the term deposit for service-based businesses. Deposits are more like in the landlord-tenant law, like world, where you get your deposit back if you clean the apartment and leave it as you found it kind of thing. But if you have the term deposit in your contract, please switch it out to retainer, please, 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 for future bookings and purposes for contract signing. If you have the word retainer and you have the words non-refundable, then it's looking again like you could say, you have to decide, do you want to hold steadfast on what your contract says? If they're threatening a lawsuit and they're just being not good clients, is it even worth it to continue to interact with those clients? Probably not. They're probably not your ideal clients anyway, and their true colors are coming out. If they want a full refund of $2,500 or whatever it is, even if that's going to be a financial burden on yourself, it would probably be better under all of these situations to refund them. I don't suggest that is step one, but I have to be very frank and honest with you guys as an attorney, and being in so many of these bad situations with my clients where $2,500 is a lot better than $10,000. And that is probably what it would be to get into court. Even if you are the defendant on the case, the plaintiffs have to pay a lot of money too. That's also something to remember. This is my last little tidbit here on this podcast episode. Clients could threaten all they want, but for them to actually do it, it's expensive to try to file a lawsuit and to get an attorney to file it for you. And then they have to go find a plaintiff's attorney that actually thinks their lawsuit is worth it and will represent them. Filing pro bono probably is not going to happen for these type of situations because it's super fact specific and law specific and case precedent specific, which we also don't have a lot of case law on this. So a lot of attorneys are like, well, I don't really know. We're all going to see lawsuits coming out of COVID-19 period of time this year. In the next 12 months, 24 months, we'll actually get some courts interpreting, contracts, and we'll have some actual case precedent on what to do. But right now we don't. So even if they threaten it, you have to realize you are a business owner. You have contracts for a reason. I don't ever suggest being like, oh yeah, I'm just going to give a refund. That's what someone told me to do. Here you go, as the first step. But it potentially might be something that comes up down the road, and you are going to have to make that decision for yourself. You have to decide, my clients aren't budging. They're being horrible. Is this worth it? Can I just give a full refund and move on? Do I really care that much to try to open myself up to the risk and liability that a lawsuit would be? I don't know. I can't make that decision for you guys. If you were my client and I was advising you as your attorney, I would lay all of this out here for you. And I would be like, you have to make the decision. This is what I would advise. If it's a $1,500 refund, I'm just like, just give it and move on. It's well worth it for your emotional state and for your business's sake. And I have one last thing. I have been seeing some force majeure clauses that state that a full refund will be given in the event of an impossible situation. Coronavirus is an impossible situation that is disallowing people to host their events and for you to perform your services because you're a non-essential worker. If that's the case and your contract states that, you're pretty much stuck having to give them a full refund because that's the agreement that you signed on with your clients. So you may have to refund depending on what your contract states. So finally, I know I've said finally a lot, but I truly mean this. Just be kind and courteous to your clients, you guys. Customer service goes a long way, and the relationship that you have with your clients from the get-go goes a long way. Almost everyone right now, clients, venues, event and wedding industry vendors, everyone is taking some kind of burden or hit during this time. This pandemic has manifested into unique financial, emotional, and physical hardships for everyone. Be aware of that and how your clients are reacting to this situation. It may be different than you are reacting, and just be empathetic towards that. Make sure you're respectful of what your clients are going through while maintaining solid business practices for yourself. Because at the end of the day, the viability of your business is at stake and you want to keep your business alive. You want to have something to tax at the end of 2020. You want to have a business that is still there. So do what's best for yourself, for your family, for your business, and do what's best for each and every client situation. And remember, there's no one size fits all solution for canceling and refunding. And I hope that this podcast episode brought that more to the forefront of your mind and to light. Thank you so much for tuning into this episode. If you want to continue the conversation further, you know that I am always active in the Legal Paige community. On Facebook, you can just type in the Legal Paige community at the top search bar. Request to join. You have to answer a couple questions, and then you can jump in there and ask me and my team more questions if you have them after listening to this episode. You guys, thank you for your time. I will be here same time, same place next week on our new episode. Thanks so much for listening to this episode of the Legal Paige podcast. See, I told you being legally legit isn't so scary. Be sure to visit thelegalpaige.com for all show notes. And it would be super awesome if you could head over to iTunes and leave a review. Last but not least, don't forget to join my free Facebook group for unlimited legal and biz Q&A. Chat soon, Legal Pagers.